our, sorry, the recording's just starting. Welcome to another one of our sessions co-hosted with STBB. Today we are focusing on commission disputes, and right at the end of the session, I'm very excited to showcase one of our newly launched features called the virtual agent. So stick around for the whole session, and yeah, we'll be showing you how you can get some new leads, which is really exciting. Before we start, I just want to run you through some of the house rules for today. So if all participants can please mute themselves and remain muted for the entire meeting. The presentation slides will not be made available as this is part of STBB's intellectual property. However, you can find any of their brochures and handouts on their website, www.stbb.co.za/brochures. You are welcome to post your comments, questions, queries in the chat, and right at the end, we'll tend to those questions. Please also note we obviously are limited with time, but we're going to try our absolute best to get to all the questions. And then any administrative queries or feedback, you're welcome to email marketing1@stbb.co.za. We'll pop that email address in the chat as well. In terms of your attendance certificates, I know that some of you are showcasing the training session maybe in an office on a big screen. So if there's more than one of you watching this training session, you're welcome to just pop an email to the marketing email at STBB and just let them know that you also attended the session so that you can also receive a certificate of attendance. So today I'm extremely excited to introduce you to our presenter, David Thompson. He is a director at STBB's Cape Town office. David brings a wealth of expertise in dispute resolution and general litigation. His specializations include corporate and commercial litigation, property litigation, evictions, insolvency, administrative law, and contract law. Today, David will share his insights on commission disputes, drawing on his extensive experience to provide valuable guidance. We are very, very fortunate to have him with us today, and I think it's going to be a highly informative session. So David, thank you for your time, and yeah, I'll hand over to you.
Thanks very much, Candice, and good morning to all the attendees, all the viewers this morning. I hope you're all keeping very well. So as Candice said, I'm in the litigation department at STBB based in Cape Town. I do also operate a litigation practice out of our Gauteng branches. We've got 4 Gauteng branches, one in Centurion, Sandton, Fourways, and Bedford View. So it's very, I suppose, unique for us, and it's very fortunate that we have such an extensive branch system throughout South Africa, so that we can provide these services to our clients on a sort of more of a macro level as opposed to a micro level. But being the big small firm and having that as our logo, of course, we do treat all of our clients as if they were our only clients. It's sometimes a bit difficult to do that, but we do try. Guys, being in the litigation practice, as Candice says, I'm involved in a wide variety of disputes and in dispute resolution. And one of the fields of dispute that I have been involved in and continue to be involved in sort of on a day-to-day basis is, of course, commission disputes. You know, one would believe and one would hope that in today's day and age, these kinds of things don't happen. And we're all colleagues and we're all friends in the industry, and, you know, we treat each other with respect and all these nice things. But unfortunately, we do continue to see commission disputes being quite prevalent in the industry. And of course, you know, when these things happen, you need to be able to have someone to turn to, and I am here. STBB is here to assist you with those kinds of disputes. So this morning, what I want to touch on with you, just briefly, I don't want to give you a long lecture about things, and I obviously do encourage interaction with the group. So at the end of my presentation, if Candace is amenable to it, I'll happily take questions from the floor. But what I want to touch on is just some sort of high-level points for you guys to keep in mind when it comes to commission disputes. And I think more importantly, how to try and mitigate or to avoid commission disputes altogether. This I think is something that we can put in our best practice hat, or put on our best practice hat, and just to make sure that we have these high-level points covered, so that either it will avoid commission disputes entirely, or if you do have a commission dispute, it will ease the process, or it will make the process a lot easier in claiming your commission. So let's start. A couple of things to keep in mind when you are wanting to set up a commission claim. As an estate agent in the property industry, one of the most important things that you have to think about before you can earn your commission is, of course, having a fidelity fund certificate in place. It is an absolute requirement that estate agents and intern estate agents have valid fidelity fund certificates in place. And that is an absolute requirement. If you do not have a fidelity fund certificate in place, it is an absolute bar to a commission claim. So you might have done all the work, you might have had a mandate in place, you might have secured a deal for your purchaser and your seller, but if you do not have a valid fidelity fund certificate in place, the party responsible for paying your commission will not be able to, you will not be able to enforce a commission claim against that person. There was a very interesting case that came up. It actually emanated from the Western Cape, and it went all the way to the Supreme Court of Appeal, where the argument went that an estate agent was not entitled to claim commission because he was not in physical possession of a valid fidelity fund certificate. Now, as we know, as I've just said, the absence of a fidelity fund certificate is an absolute bar to claiming commission. So, and this is the reason why this case went all the way to the Supreme Court of Appeal, because the Western Cape High Court said, well, because the estate agent doesn't have a fidelity fund certificate, he can't claim commission. They then took the matter on appeal to the Supreme Court of Appeal. And what was established at the Supreme Court of Appeal is that the particular agent involved had done all that they were supposed to do in order to qualify or to be issued with a valid fidelity fund certificate. And the reason why the estate agent was not issued with a valid fidelity fund certificate was because of the erstwhile Estate Agency Affairs Board. Their administrative branch had not done what they were supposed to do in time, and therefore the estate agent's fidelity fund certificate was not physically issued. You'll remember until very recently, fidelity fund certificates were issued physically, in physical form. Now they are issued electronically by the Property Practitioners Regulatory Authority, the PPRA. But this case specifically dealt with a situation where it was under the old Estate Agency Affairs Act. And luckily for us and for estate agents in the industry, what the Supreme Court of Appeal said is that if the agent in question has done all that they are supposed to do in terms of the Act, they've ticked all the boxes that they are supposed to tick. If they have done that, and the reason why they have not been issued with a valid fidelity fund certificate is because of the administrative branch of the regulatory authority, then that estate agent is still entitled to claim their commission. So the absence of a physical fidelity fund certificate due to no fault of your own would, in theory, still justify your commission claim. Okay, so that's the first point. make sure that your Fidelity Fund certificates are up to date. The second very important element of claiming commission is, of course, the mandate. You may not claim commission without a mandate. That is the, I wouldn't say starting point, because the Fidelity Fund certificate's the starting point, but when we get all the red tape out of the way, from a regulatory perspective, this is really the starting point. At this point, you have now engaged with your client, whether it's a seller, a purchaser, a landlord, or a lessee, and you have now been given a mandate. Please, guys, make sure that this is done. If it's an open mandate, if it's a sole mandate or an exclusive mandate, make sure that you understand the type of mandate that you're operating under. A mandate can be express, or it could be tacit, but you still need, at the end of the day, it's going to be the agent's responsibility to prove that there was a mandate in place. When it comes to open mandates, as we know, this type of mandate, it can be given verbally, and it does not need to be in writing. Okay. And the general rule of thumb with open mandates is that the agent who closes the deal is the agent who's the effective cause, and it's the agent who's entitled to their commission. Just for the sake of the group and perhaps for future talks, and also Candice, I'm more than happy to give the group an exclusive talk on mandates, and we can unpack mandates in more detail, perhaps in a different talk. But for now, I'm just going to limit it just to the purposes of this presentation. So that's an open mandate. A sole or exclusive mandate, on the other hand, guys, remember, this has to be in writing, okay? It's an absolute requirement, and it has to be in writing. And that sole or exclusive mandate must be for a specific period of time. It must be for a specific duration. Yeah, it has to be in writing. So please remember, when you are obtaining your mandates, make sure that you understand, is it an open mandate? Is it a sole or exclusive mandate? Open mandates can be given verbally. Best practice, of course, would be in any event to reduce it to writing. And then your sole or exclusive mandate, that needs to be in writing, and of course needs to be for a specified period of time. Okay. The next element of ensuring that you have a solid commission claim is due performance of the mandate. What does due performance of the mandate mean? In very, very broad terms, what we're looking at here is there must be an introduction by the agent of a purchaser to a seller, or the other way around, depending on who you have been mandated by. There must have been the purchaser was, when the contract was signed, willing and able to purchase the property. Obviously, depending if you have mandate from a seller or a purchaser. There must be a valid contract of sale that was concluded pursuant to your introduction, and your introduction must be the effective cause of that sale coming to fruition. So it's very important, guys, that we understand, not only is it necessary for us to have a mandate in place, we've got to fulfill that mandate. And of course, as we know, depending on the terms of the mandate and depending on all sorts of technicalities, when it comes to effective cause, there may be situations or circumstances where you have introduced someone to a property in passing, or because of an advert or whatever. And it might be that you are not necessarily the effective cause of that transaction. So it's very, very important for agents to understand that in order to claim their commission, they have to fulfill the terms of their mandate. They have to be the effective cause of the sale. An effective cause can obviously, it can happen during the mandate period, and it could possibly happen after the mandate period as well. So it's something to bear in mind, to understand how long the period of your mandate, how long your mandates are enforced for. And it's also very, very important, guys, once your mandate has been concluded, terminated, cancelled for whatever reason, just make sure that you are protecting yourselves by giving your purchaser or your seller a list of people that you have introduced to the property. This is what we would call an exclusion list. And of course, that by notifying your client of the people that you have introduced to the property, that should be an exclusion to the purchaser and or the seller in dealing with that person. And also that you should ask your erstwhile principal that they share that list with any other agent that might be employed to work on a particular property, so that the subsequent agent also knows who you have introduced to the property. Now, it's not to say that if you have an exclusion list and your seller intends concluding a deal with someone that you have introduced to the property after your mandate period has expired, that they can't deal with that person. It simply means that you may be entitled to claim commission because of that introduction. But once again, that would depend on whether or not you have fulfilled your terms of the mandate and whether or not you are the effective cause of that particular sale coming to fruition. So that's briefly on due performance of the mandate. The last thing, just from a high-level perspective, in order to claim your commission, there must be an agreement on the percentage of commission that you are claiming. And does that percent include VAT or does it exclude VAT? I presume in most cases that this would the percentage which would exclude VAT, which means that you must stipulate the percentage plus VAT. I presume that that would be in the majority of cases. If not, if you're not a VAT vendor for whatever reason, then your percentage would be inclusive of VAT. If it so happens that you, for example, have taken a verbal mandate, an open mandate, and you are so good at your job that within 24 hours of taking that mandate, you've already found a purchaser willing and able, deposit is ready to be paid, and happy days. But because you're so fantastic at your job, you have not yet had an opportunity to discuss your commission percentage with your principal or the seller or whoever has instructed you. That is not necessarily a complete bar against you claiming commission. The courts have held in those circumstances, the agent should be entitled to claim a reasonable market-related commission for the particular transaction in question. And what reasonable market-related commission looks like obviously differs from province to province, and within provinces, it differs from area to area. You might find that if you're operating on the Western Cape, Atlantic Seaboard in Cape Town, that if you're selling 100 million rand properties or 150 million rand properties, that you might only be taking a commission of 3%, maybe 2.5%, whatever the case may be. But if you're operating in an area, say, for example, like Sandton in Johannesburg or Bryanston in Johannesburg, maybe your commission is a little bit more. Maybe it's 5%, maybe it's 7%. So that would depend on area to area and province to province. So it's the moral of that story is that if you have not discussed a commission split or commission percentage with your seller, it's not necessarily an absolute bar to claim a commission. Obviously, it would be ideal if that percentage was included, but don't fear. STBB has your backs, and we will, if instructed, we will ensure that, or we will certainly endeavor to ensure that your commission is paid. So guys, those are the four sort of very, very high level points to keep in mind. And just to make sure that you have these things in place in advance, just to make sure that your commission claim is not going to be compromised by technicalities at a later date. So just to recap, make sure your FFC is up to date and in place. Make sure that you have the necessary mandate in place, whether it's oral or whether it's sole or exclusive. Just make sure that you have the necessary formalities in place there. If you are instructed to do something by virtue of a mandate, please make sure that you give your best effort in fulfilling the terms of that mandate. And then lastly, please make sure that you discuss upfront and agree with your seller about the commission percentage that is going to be paid to you as the agent, and or whether that includes or excludes VAT. So those are sort of the high-level technical aspects that you need to be aware of. There are a couple of other things. I've just made a note of a couple of them that you guys should also be aware of when it comes to ensuring that your commission claim is not going to be compromised or challenged too vigorously down the line. The first thing, once you've done all the lovely things and you've ticked all 4 boxes as we've discussed this morning, and it comes time to sign the OTP, please guys, please remember at the back, normally on the last page of the OTP, there is a space for an agent to sign to accept the benefits of the offer to purchase. Please make sure that the principal of the agency signs that and accepts those benefits. It is very, very important that you do this for more than one reason, more than just a commission reason, but obviously predominantly because of your commission. This evidences that you have accepted the benefits of the offer to purchase. And why is that important? Well, because your commission is dealt with in the offer to purchase. The offer to purchase or sale agreement is generally a contract between a seller and a purchaser. The agent is not generally a party to that contract. So generally speaking, the agent does not have the right to enforce terms of that contract. However, when the agent accepts the benefits of that contract by signing that little space in the last page of the offer to purchase, the agent brings themselves into the contract, and you now become a party to a certain extent to that contract, and you then start having rights and obligations that flow from that agreement. And most importantly, you have a right to claim your commission. If you don't sign the acceptance of benefits, it's not an absolute bar to claiming your commission. I, however, would recommend that you do it and you make it part of your best practice, that you always, without fail, accept the benefits of the offer to purchase. This just avoids unnecessary disputes in the future, and it certainly evidences that the agent has accepted those benefits and is entitled to claim their commission, which flows from the agreement. The other very, very important thing, and I think that we're only starting to see the tip of the iceberg when it comes to disputes around this. It's a very interesting point. But in terms of Section 67 of the Property Practitioners Act, as you may or may not know, a property practitioner must not accept a mandate unless the seller or lessor of the property has provided him or her with a fully completed and signed mandatory disclosure form in the prescribed form, and provide a copy of the completed mandatory disclosure form to a prospective purchaser or lessee who intends to make an offer on the purchase or lease of a property. So guys, this is a mandatory requirement in terms of the Property Practitioners Act, the mandatory disclosure form, which is the property condition report, as we also refer to it. Very, very, very important. The property condition report must be completed and signed at the time that you take your mandate, okay? If you don't do that, arguably, and I say arguably because I'm actually involved in a matter like this at the moment, and it is arguable, there is a challenge to the legitimacy of the mandate. I'm of the personal view, without having received any court decision on the point as yet, that the failure of an agent to comply with this section doesn't necessarily bar you from claiming your commission. It doesn't necessarily invalidate the mandate that was given to you, but please be warned, guys, there are repercussions for failure to adhere to this. The agent may be held liable for their failure to do this. And I would highly recommend and suggest that you follow this and you do this as a course of best practice within your business. It avoids issues down the line. It avoids unnecessary arguments. It's a simple exercise that you can get a property condition report completed and filled out and do it. If for whatever reason your seller has never lived in the property, or your seller has not lived in the property for a very, very long time, and they are not aware of the condition of the property, my suggestion would be either that the seller employs someone to do a property condition report, a full property condition report, an inspection of the property, and give that to a potential purchaser, or possibly a cheaper option, but not necessarily without criticism, is for the seller to simply record in the property condition report that they have not lived in the property for X amount of years. They are not aware of any defects per se, but that the purchaser it is suggested that the purchaser obtain their own property condition report in due course. And we hope that will be sufficient enough to protect sellers and agents alike going forward. Of course, what the property condition report is, it's nothing more than a representation of what the property condition is to the best knowledge of the person completing the report. Okay. The next thing, guys, just something to be aware of when it comes to suspensive conditions, and obviously claiming your commission. In terms of the regulations to the Act, it says that no estate agent shall demand or receive commission from any contract of sale or lease which is subject to a suspensive condition until such time as that condition has been fulfilled. We all know that if a property is suspensive or is subject to, for example, the granting of a bond, if a bond is not granted, barring very technical arguments, if a bond is not granted, the agreement lapses and there are no rights and obligations that flow from that agreement. And by virtue of that, you are not entitled to claim your commission. The other thing that the regulations say is that if the sale is subject to a resolutive condition, you may not claim your commission for such a period of time during the resolutive condition period that the transaction might fall away. So just be aware of those two conditions in your regulations, in your industry regulations, and just be mindful of that when you are completing contracts, to understand the difference between a suspensive condition and a resolutive condition. Then when it comes to suspensive conditions, particularly with regards to bonds, guys, please be aware of the time period that is afforded to a purchaser to obtain a bond, and also the automatic extension of time that is sometimes afforded to parties in offers to purchase in order to obtain a bond. Sometimes those automatic extension of time clauses are given at the discretion of the agent. I have seen sale agreements that say if the bond is not granted within 30 days, for example, then there'll be an automatic extension at the discretion of the agent. Once again, that brings me back to the part of the offer to purchase that you need to sign on the last page of the offer to purchase, which brings the agent into the agreement. If the agent has not done that, then they can't be said to have exercised a condition in a bond clause that gives them the right to extend the bond grant period. So little technicalities that sometimes help us in the industry to get over little hurdles and challenges. And yeah, guys, that's me for now. I hope that has been informative, and I am very open to receiving questions from the floor. If there are any questions, I'm happy to try to answer some of them.
Cool. There haven't been any questions yet. Let's give it a little bit of time and see if anybody's got any questions.
Hello. Sorry for my voice, I'm a little sick. Don't know if you can hear me properly. Is there a time frame for a mandate? In other words, not from a mandate, from an introduction. Say, for instance, you introduce a client to a property in January. Is that your introduction for life?
Sorry, Candace, I didn't quite get all of that.
So I heard the one part. Is there a time frame for the mandate?
No, for the introduction.
For the introduction.
If you introduce a potential purchaser to someone, how long is that valid for? In other words,
yes.
Okay. There's no set time period on that. It all boils down to effective cause at the end of the day. So if you have a valid mandate and you've introduced 6 people during your mandate period, and your mandate comes to an end, and then one of those 6 people purchases the property, say 3 months later or 4 months later, without anything more. So in other words, the next agent that gets the deal or gets that particular purchaser, they've done nothing more than what you've done. Arguably, you are the effective cause. But what that time period looks like, there isn't a set time period. It's all going to be circumstance related.
Okay, then we've got another question. Please reconfirm the difference between suspensive versus resolutive conditions.
Okay. So a suspensive condition is your typical example would be a bond. The contract is subject to a purchaser obtaining a bond within 30 days. If the purchaser is unable to obtain a bond within the prescribed time period, the agreement dies. It is of no further force and effect. You do not have any rights and obligations flowing from that agreement, generally speaking. I'm just speaking in general terms. Obviously, there are always nuances and exceptions to the rule, but generally speaking, that is the position. A resolutive condition is if the agreement comes into place, it's fully effective, but it might terminate if something happens in the future. So say, for example, you sell a business as a going concern, and there is a resolutive condition that the purchaser must obtain an operating license within 30 days or 60 days. If that doesn't happen, the contract can come to an end, and you may not claim your commission during that period.
Okay, another question. In a previous training session, the trainer said that a vacant stand does not need an MD document. What is your opinion on this?
I don't think that the Act differentiates between vacant land and improved land. I stand to be corrected. I can perhaps check that while we are during the rest of the presentation. But I don't think that it makes a distinction. It just says that a property condition report must be taken at the time of taking the mandate. And I don't understand that there is a distinction. If the property is vacant, you simply say the land is vacant. However, if the land is vacant and it has a sinkhole on it, you should disclose that. So there are things to disclose even if a property is vacant.
Okay, what happens when the tenant who are introduced rents a property knowing the property is for sale and buys it through a second agent or the seller directly?
So agent 1 has introduced a tenant to a property. Tenant is aware that the property is for sale. My first question is, who has the mandate to sell? Then my second question is, normally lease agreements do have a for sale clause that says something along the lines of, if the tenant purchases this property, the agent who introduced the tenant is deemed to be the effective cause. So there might be 1 or 2 permutations there that we need to look at, but yeah, I mean, that's sort of the general position as I see it.
Okay, then Lydia asks, if you are mandated to sell a development, why are the attorneys only keeping me covered for the land portion but not the building portion? The developer or contractor has yet to pay me for the top structures.
That I'm not sure. I think that would depend from development to development, and we would need to look at the contracts in place. I won't be able to give a general answer there. Sorry.
Okay. Are we entitled to commission as interns, and how do we split it with our host employer?
The commission split between interns and principals is dealt with internally within the agency itself, but interns are entitled to commission, which is one of the reasons why interns have to have FFCs as well.
Okay. Is a disclosure needed for a new development?
Yes, once again, I don't think that there's a distinction between the type of property that the agent deals with. So whether it's a vacant land, whether it's a second-hand home, whether it's a new home, my understanding is that that property condition report must be signed and completed at every time you take a mandate.
Okay, then good morning, David. For example, it's an open mandate and there are 2 agents. If a buyer submits an offer on a property via agent 1 and the seller accepts the offer, the purchaser then realizes that they are not happy with the terms and conditions of the first agent or company's OTP. Can the purchaser refuse to proceed with company 1 and then go to agent 2 and then ask the agent 2 to negotiate an offer?
Highly unlikely. That to me sounds like there might be a breach of the mandate itself. So you'll have a pure contractual claim, damages claim stemming from your mandate. If there isn't any real effort by agent 2, there might also be an effective cause claim. Remember, effective cause and mandate claims are slightly different. They can be slightly different. But in that case, no. If it's just a question of purchaser not liking the agent anymore, I don't think that that's going to be enough to get you over the line. I think agent 1 will have the commission claim.
Okay. If you signed an OTP and both parties signed, but the purchaser did not perform, however, a year later, he went to the purchaser and they signed a deal without the agent, are you still the effective cause?
That'll depend on the circumstances of the second deal. If absolutely nothing has changed, price is the same, bond or cash, all of those obstacles have been removed, nothing has changed, it's just a lapse of time, arguably you are the effective cause.
Dave, I got a tenant for a landlord and then he informed that he wants to sell the apartment. Tenant said he'll buy after months and he's sorting out some stuff. Landlord directly contacted the tenant and got her to sign a sale agreement. When I returned, tenant informed me the seller was not responding to me at all. He's not responding to my correspondence and property registered in August.
Yeah, that sounds a lot like the other question that we had. You would need to look at your lease agreement. A majority of lease agreements nowadays do have that for sale clause, which says that if the tenant purchases the property from the landlord, the introducing agent is deemed to be the effective cause. So we would just need to look at that.
Okay. What happens if a purchaser decides not to continue with the purchase, even though the property was to be bought cash, but used the fact that the seller sent acceptance of offer about 2 hours before expiry time?
Sorry, 2 hours before expiry.
Expiry time, yeah.
If it's before it's expired, then you've got a valid deal, generally speaking.
Okay. What would you say it means when you get a referral property from another agency and your principal says 20% off the top, but once the commission gets paid out, the principal calculates the referral com of the top, but deducts the whole 20% off the agent's part?
I'm not entirely sure. I'd need to pull that apart a bit. All I can really comment is to say that splits are dealt with internally. So the agent and the principal, or the intern and the principal, there must be some sort of agreement that deals with splits. So your first point of reference might be that. But I need to look at the numbers a bit more carefully for that one. Sorry.
If an intern gets a listing, is it the senior sales agent list it on behalf of the intern, or the intern can list the property?
So my understanding is that the intern can list the property, but they do need to be assisted by their principal in concluding the transaction.
Okay, if a client contacts you and says that they have put in an offer with agency one, but agency one either refuses to present the offer because it's too low, or says that the offer was not accepted and asks you to present an offer, which is then accepted and who is due commission?
Sorry, Candice, can you give me that one again?
So if a client contacts you and says that they've put in an offer with an agency, but the agency either refuses to present the offer because it's too low, or says that the offer was not accepted, and the client then asks you to present an offer, which is then accepted, who is due the commission?
Yeah, so on a very high level basis, agent two would have arguably been the effective cause if the deal actually goes through, because they presented the offer. I mean, agent one can't really be said to have been the effective cause of, they just refused to do something. There might be an issue if there's a sole agency with agent one, but if it's an open mandate and agent two gets the deal over the line, I can't see agent one being too upset about that.
Okay, nearly done with questions. Is the intern's commission fee taxable?
Earnings are taxable in South Africa. It depends what your earning threshold is.
Who pays for costs of the litigation if all the conditions were met by the agent?
It depends who wants to enforce the contract. So if for example the purchaser and the seller sign a mutual termination agreement, and in terms of the offer to purchase, it says if that happens, one or both of them become liable for commission, and one or both of them refuse to pay commission, then the agent would need to pursue their commission claim against the party responsible. And if the agent is successful in their endeavors, they would be entitled to recover a portion of their legal costs from the responsible party. Remember that litigation, in litigation, you never recover all of your costs, unfortunately. It's a percentage of your costs that you recover. So the general one, sort of ABC, is that the agent would come to myself, for example. The agent would pay my fees. We would go off and we would sue whoever. If we are successful, the agent would theoretically then be reimbursed a percentage of what they've paid me.
Okay, during an open mandate, agent one introduced a buyer to the property. Subsequently, mandate was changed to sole mandate at a reduced price to agent two. Does agent one have any claim?
I don't think so. If it was an open mandate, unless the agent one has introduced someone to the property and that person subsequently concludes a deal with the seller, there might be an effective cause claim. But I don't think from a mandate perspective, a purely mandate perspective claim there.
Okay, and last question. David mentioned that for open mandates, it is not necessary to be in writing. How should it be then that there must be a written property condition report?
So the written property condition report isn't the mandate. The mandate is the document that sets out the contractual relationship between, let's say, the seller and the agent. And in that contract, you would specify the parties. So seller and agent, you'd specify the duration of the mandate. You'd specify the commission split or the commission percentage. And you'd specify, for example, the normal stuff. If you conclude a deal with someone I've introduced you to in the next 6 months or whatever, I'm deemed to be the effective cause. So that's the mandate. The property condition report is something that is governed and stipulated by the Act. And that isn't a mandate. That is a separate standalone document that needs to accompany your mandate. So you can have an open mandate that isn't in writing, or that's negotiated over WhatsApp, but then you have to have the written property condition report, which obviously goes a long way in as evidence to show that you have a mandate. But the two are different documents.
Awesome. Thank you, David. Appreciate your
Pleasure.
time. Was very informative. Before we close, I just want to do a quick demonstration of our recently launched Find an Agent portal. So I'm going to quickly share my screen. Share. All right. So we have not launched to consumers as yet. We want to get all our clients to start updating their profiles, which I'll show you where to do. But once we do launch to consumers, you really would want your profile to be 100% complete so that you can be found first when a potential buyer or seller comes and searches for agents. The whole reason we launched Find an Agent is because we often find that a potential buyer or seller goes onto other listing portals, they look for properties, and often those properties are no longer available. I just know from personal experience when I wanted to rent a property, I go and look for the expert agent in that area because I know they'll be able to show me all the really good properties in that area instead of actually looking for properties first. So our goal was to match consumers with agents. We obviously have a lot of agents using the virtual agent. So yeah, once you upload your profile pictures, etc., then you will start getting leads from the virtual agent. So once consumers come to Find an Agent, I'm going to show you quickly what it looks like. This is our soft launch, so there's still going to be a lot more changes. I'm going to do a search here just on one of our sales team. She's added herself. She's added that she's an investment professional and she works in Umhlanga. Go and find agents in Umhlanga. And there she is over there. So a potential buyer or seller can go and view her profile if they want. They can then go and see over here what sort of award she's got, how many properties she sold, a whole bunch of information about her. And from there, they can either send her a message, they can call her, or WhatsApp her as well. So yes, we're going live with this to consumers from probably around early next year, January. But in the meantime, I want to really get you excited and get you on board to start updating your profiles. So when you log into TVA, just jump in over here, you will see if you go to Find an Agent, there's a new tab over here. It says New, Find an Agent. This is your dashboard once you start receiving leads. So in order to receive leads, in order to start pulling up onto Find an Agent, you need to go to your profile at the top over here, click My Profile. Very important that you go and upload a profile picture. So the search engine is obviously based on algorithms, and it's going to pull up agents' profiles in a specific area that has their profile picture uploaded. If you've got a company logo, go and complete your profile. The more you complete, the better chance of your profile pulling up first. go and add your farming areas. So really important that you add the specific area that you specialize in, so that you pull up when a specific buyer or seller or tenant is looking for property. And you can then choose over here. So it's a little toggle over here, whether you want to be on Find an Agent or not. I would suggest make yourself viewable. We're letting Google crawl the site at the moment, so get yourselves onto Find an Agent by simply just completing your profile, and then once we do go live, hopefully you get a whole bunch of leads coming through. Once you do get a lead, it will obviously pull through into your Find an Agent dashboard. Remember, with the virtual agent, you are able to validate clients against our client base. So I just want to quickly show you what that would look like. So let me just share. For example, once you get a lead, it would automatically pull through. And from there, you can go and validate the individual. You can then add them to your CRM. You can go and do a FICA and fraud check on them. You can add them to your deal tracker. You can then list their property via the virtual agent. You can see this is just an example, but if this was a really good agent getting a whole bunch of leads, they've got a lot of prospects, client calls, the messages, their listed properties, and they can see their client growth year to date over there. And then all their clients are obviously over there, and what sort of clients they are, and exactly like your current CRM works, but now your leads would filter straight into your Find an Agent dashboard. So really exciting. I want to encourage you, go and get your profiles updated. We're very excited to launch. We've only shown one of the groups that we have on board, the Find an Agent portal. So you guys are all first to see it. So hope you're going to love it, and hopefully next year you start to get lots of leads from the portal. So that's it from me. I just want to say thank you again to David. Thank you to STBB for such an informative session. And we will see you all again in the next up and coming session in the next 2 months. Have a great day, everyone. Bye.
Bye.